Hello, and welcome to Investment News' mid-year roundtable on regulation and legislation. Before we get started today, I'd like to make a few introductions. To my left is Mark Sheff. He is our Washington reporter. I'm sure all of you know him and read his stories. Mark is going to be co-moderating with me today. Going around the room, to Mark's left, we have David Tittsworth. David is Executive Director of the Investment Advisor Association. We also have Dale Brown, who is Chief Executive of the Financial Services Institute. Jumping over the table to his left, we have Heath Abshure, Arkansas Security Commissioner and President of the North American Securities Administrators Association. We also have Ira Hammerman, General Counsel for the Securities Industry and Financial Markets Association, and Marilyn Mohrman-Gillis, Managing Director of Public Policy and Communication for the Certified Financial Planner Board of Standards. So I guess in kicking this off, I'm going to let Mark ask the first question.
We'll start with an issue that's top of mind, no doubt, for everyone around the table. In a few weeks, comments are due for a cost-benefit analysis that the SEC is conducting on a potential uniform fiduciary duty rule. This rule has been considered for a number of years, and now we're to the cost-benefit analysis stage. David, we'll start with you. IAA and 8 other groups sent a letter to SEC Chairman Mary Jo White last week expressing concern about the parameters of a potential uniform standard that were included in the cost-benefit analysis. And your letter said, referring to the parameters, this approach would have negative consequences for investors and is one we would vigorously oppose. Could you elaborate on what your concerns are at this stage about the direction that the uniform fiduciary standard is going?
Absolutely. Fiduciary duty, I thought that was settled years ago. Now this thing has been going on. I think I signed our first comment letter on the SEC's fiduciary rule back in 2000. So this debate has been raging for well over a decade. And our organization has certainly been involved. We recently joined with our friends at the Financial Planning Coalition and the state securities regulators, some consumer organizations, to write the letter to Chair White that you referred to, Mark. And by the way, for people who read these joint letters, trying to get 7, 8, 9 groups together, you might just read it and think, oh, you know, those groups, they're always walking in lockstep. It took a lot of effort to get that page-and-a-half letter put together, but the question has always been, what should the standard of care be for people who are giving investment advice to their clients? And so our organization and like-minded organizations have for years said that it is appropriate for the highest standard of care, the fiduciary duty, to attach when people are giving investment advice. And Congress has certainly gotten into the act. There is a provision in Dodd-Frank, Section 913, which I'm sure everybody here is very familiar with and will talk about, but there is a potential for a rulemaking on that subject. The SEC on March 1st published this request for information. It goes to a lot of cost benefit and other issues. We'll certainly respond to that letter, as will all the people around this table, I'm sure. But we believe that, again, that the Advisors Act fiduciary duty, which has been in place for decades, certainly confirmed by the United States Supreme Court in a decision in 1963. It's been consistently interpreted by courts and the SEC. That is the fiduciary duty that should attach.
And your groups are saying if that's not the fiduciary duty that attaches, it's better not to do anything. Is that right? And how important is that statement? I mean, you guys have been working on this for years, and now you're saying, forget about it.
Yeah, I don't think it's anything new from my perspective, right. But I'll let others certainly talk about it. But I think that the fiduciary duty, the well-established fiduciary duty, if the SEC were to water that down considerably, yeah, it'd be better if they did not do that. So that's one of the points of the joint letter. It's certainly a point that we've said for a long time. Don't water down this duty that has been very well established, and don't create different standards of care for different types of clients. When we get into the details of 913, it's providing personalized investment advice to retail clients are the operative terms in the statute. But the SEC has authority to extend that to other types of clients as well.
And Ira, let me turn to you. Throughout the cost-benefit analysis request, the SEC says repeatedly, we may not follow these parameters when we draft a rule. But nonetheless, one of the parameters states this: the uniform fiduciary standard of conduct would apply within the context of the scope of services agreed to between the customer and the broker-dealer or investment advisor, and would not generally require the broker-dealer or investment advisor to provide services beyond those agreed to through a contractual or other arrangement or understanding with the retail client. That sounds a lot like the fiduciary framework that SIFMA submitted in July of 2011 to the SEC. What do you think about the request for information and the parameters?
Well, Mark, look, I think first you have to go back to the basic premise of the request. And the SEC bent over backwards to remind everybody that they haven't made up their minds. This is a list of 70 pages worth of questions, and they want feedback from everybody, the folks around this table, as well as other commenters. And if people have other ideas or suggestions, they're inviting that as well. I think at SIFMA, where we kind of start, the first principle here is the what. You know, you heard David talk about the what. Well, for us, the what is having a fiduciary standard of care when personalized investment advice about securities is being delivered to the retail investing public. Now, that's a long sentence and it's a mouthful, and every term needs to be discussed and defined and so forth. But for 4 years now, David was talking about comment letters going on for years and years. It was 4 years ago that SIFMA publicly embraced a uniform fiduciary standard of care for retail clients. So I think we're agreeing with the what of fiduciary standard, and what I think we all need to spend a lot of time talking about is the how it should be implemented. You heard some reference to the Investment Advisors Act fiduciary standard, well-established, Supreme Court case from 1963. Look, the act has been on the books for almost 74 years. I think what we're suggesting is a fresh look by the SEC as the expert agency in securities matters to take the best of the existing Advisors Act, best interest of the customer, a duty of care, a duty of loyalty, taking those principles and putting them hardwired into a regulation that would apply equally to the Advisors Act side and to the broker-dealer regulatory side. And I think everyone should have the comfort that within Dodd-Frank itself, the actual law, it prevents any watering down. No one's looking for fiduciary light or any sort of minimal fiduciary standard. But what we are looking for is clear guidance so that as we all move forward, whether you're on the investment advisor side or the broker-dealer side, and just as a quick footnote, the SIFMA membership has both. Our members are both registered investment advisors, registered broker-dealers. So we have all different shapes and sizes and business models. So what we're looking for is for the SEC to move forward, and credit should be given to them for taking us to this next part of the process, the cost-benefit analysis, and SIFMA, like the groups assembled, will be responding.
But SIFMA must be pleased that one part of the backboard that's being used to respond against is an idea, like I said, that sounds a lot like your fiduciary framework, right?
I don't take pleasure or a whole degree of comfort because I think, as I said at the outset, that the SEC is trying to be, very transparent and indicate a whole list of different ways forward, and they're looking for comment and feedback.
Marilyn, why don't you chime in here?
Well, I was really happy to hear Iris say best interest of the client, because We are also signatories on the letter, and one of the, if you actually put in place a fiduciary standard that is consistent with the assumptions that were outlined in the SEC's request for information, a key concept of the fiduciary standard is missing from those assumptions, and that is the best interest of the client. Other assumptions seem to lead to a disclosure-only type of fiduciary standard. And in our view, a disclosure-only fiduciary standard is not a fiduciary standard. It has to be based in the rock-bottom principle of the best interest of the client. So we really felt it was important to signal to the SEC that the assumptions that the SEC very carefully laid out in that 70-page document, if put into a rule, would not be what we think is a true fiduciary standard of conduct.
But and Dale, let's get you into this. Even Barney Frank, though, before he left Congress, wrote to then chair of the SEC, Mary Shapiro, saying that the Dodd-Frank Act did not give the SEC license to lay the 40 Act over brokers, correct? So what do you think about the direction that this issue is going?
Well, before I just had a couple of kind of thoughts, a couple of points that inform our view on this issue. FSI members are independent broker-dealers and the independent advisors that they license, and as such, similar to SIFMA members, our members operate under both the broker-dealer and investment advisor rules, and have therefore significant and growing component of their business operates fully and successfully under the existing fiduciary standard. The second thing that informs our view is we think that we should all continue to look for ways to expand access to affordable and quality advice for everyone. Now, the wealthier among us will always have choices and options. It's the smaller investor who far too often faces the potential of getting priced out of the reach of affordable and competent advice. So our view is similar to what Ira has articulated. We think what would be best for investors in the industry is a new uniform fiduciary standard that encompasses the principles of putting the best interest of the client first, making sure that the client's fully informed through appropriate disclosure, and that all conflicts of interest are managed and managed successfully so that the client has options, gets good advice, it is afforded the protections that come from a fiduciary standard. Yeah, I think to your question, Mark, I think Mr. Frank made it expressed, while nobody else signed his letter, I think it was pretty clear that the intent of Congress with the language they chose and negotiated to insert in that section of the Dodd-Frank Act was to give the SEC the latitude to study and explore the options, but then to kind of put some guardrails around so that they wouldn't simply come and impose the 40 Act standard on broker-dealer activity. Right. Our bottom line is looking to avoid those unintended consequences of giving advice to the small investor.
So can I just ask the last question to you, David? There have been concerns raised about linking harmonization with the fiduciary rule, and should those two issues be linked together, or should are they separate issues?
I think they're totally separate issues, and for my money, I'd just soon see harmonization go completely away, Fred. But certainly some people, some groups have linked them. There are provisions, questions in this request for information that is outstanding by the SEC that allude to harmonization issues. If you're going to deal with harmonization, which to me is a code word for taking the broker-dealer rule book and imposing it on investment advisors, not the other way around. That's how anybody that has used harmonization seems to use that particular term. For a number of reasons, we think that's completely wrong-headed. There's no good information or evidence that requires that sort of analysis. Look, investment advisors are comprehensively regulated right now, And that's part of what's been missing, in my judgment, from the harmonization debate, is a recognition of how investment advisors are already regulated. They're subject to all sorts of rules and regulations, as well as the overarching fiduciary duty. So I'm no fan of harmonization, in case you didn't pick that
I
up.
guess not.
Could I jump in here
Sure.
just real quick? I think that, I mean, what I'm listening to, I think we're all kind of saying the same thing. I think all of us agree that the fiduciary standard that should be applicable to broker-dealers is no less stringent than that applicable to IAs, which is act in the best interest of your clients. However, as Ira was saying, it's the context that makes the difference. And it gets back to the point you just made about harmonization. The reason harmonization doesn't work is because the contextual application of the fiduciary duty to broker-dealers is different than the application of that duty to IAs, even though the duty itself could be exactly the same. And if I understood what Ira said, what we should be focusing on is how should it be implemented? You know, can there be clear guidance? Well, you know, I think that worrying about the context, I don't know that the SEC is ever going to be in a position to anticipate every factual scenario, every possible scenario that could occur at a broker-dealer firm, and be able to draft a rule on the front end that applies to every possible scenario. And I don't think that's the way the law works. We go as far as we can, we anticipate raw issues, and then as the tricky, hairy issues come up, we do what we can with them. But in dealing with the question on disclosure, you know, one of the things we've talked about is allowances under the broker-dealer model. And I think by definition, whenever you have if we have a fiduciary standard that's applicable to broker-dealers, and then you start talking about allowances, you've just required a discussion about heightened disclosure. Because at some point, if there are allowances, the broker-dealer is going to be sitting there in front of their client, and the fiduciary standard is going to apply, and all of a sudden it's not, then it's going to apply, then it's not. Well, we've just created a disclosure issue that also has to be considered whenever we consider rulemaking surrounding the fiduciary duty.
Right. Thank you, Heath. Let's move on, though, to a related subject, and this is, of course, the Department of Labor's fiduciary rulemaking. Dale, I'm going to direct this to you. So it doesn't look like they're going to come out with their proposal in July like they had planned. Do you have any sense of a timetable for when we might see something there?
Well, thankfully, I think we do. When this was first proposed in 2010, we were caught flat-footed. We hadn't had a good engagement, good relationship with the Department of Labor. We've worked hard since then to build a relationship and mutual trust, frequent communication. Our understanding is their timetable has been pushed further into the year. We're operating under the assumption now we'll see a proposal perhaps in the fourth quarter.
Okay. Do you have any idea of how that re-proposal will look different from the original proposal?
In spite of frequent communication and working on a good relationship, they've played their cards pretty close to the vest. They've not revealed a lot of specifics. Assistant Secretary Borsey has recently, though, in a couple of public forums, indicated her focus is on conflicts of interest and conflicted advice. And our concern on at least using the original proposal as the baseline, our concern is, again, I'm going to sound like a broken record, unintended consequences, particularly on small investors. The original proposal sweeps in individual retirement accounts.
Right.
The average individual retirement account balance is $27,000. So I can't remember the number of how many millions of IRA accounts there are, and how will those accounts, under an expanded definition of fiduciary, still be able to get access to the retirement planning help they need? That's our focus in trying to impact the final rule proposal.
Okay. Marilyn, I see you nodding your head. Do you have any thoughts on this?
Well, we don't know exactly what this rule is going to look like, but we do know Assistant Secretary Borsey has indicated that she has listened very carefully to all the input from the industry about the potential impact of this rulemaking and has taken that into consideration in the revised rule. She has also indicated that she is in discussions with and collaboration with the SEC so that something that is prohibited under 913 would not be allowed under under the DOL rule and vice versa, so that there can be some level of coordination, and that she has engaged in a very extensive cost-benefit analysis in support of the rule. So we do know certain things. And from our perspective, the notion of strengthening the fiduciary standard under ERISA is a basic principle that we support, and we are watching to see how this rule actually comes out before any comment or reaction to the rule. Right. And one of the concerns that we have is that there seems to be a lot of sort of opposition being drummed up against the rule even before it has hit the light of day. Mm-hmm. And I think it's important to evaluate the rule. I think that she's been operating in good faith to come out with a proposed rule that will hopefully achieve the principles that they've outlined.
So is it opposition against the rule itself, or the proposed rule that we don't know about yet? Or is it opposition about the fact that you have these two entities kind of treading the same ground, and the possibility, that, and I'll let you answer this, David, that there could be contradictions in those rules?
Yeah, I'd like to. I think there's a lot of confusion about the DOL and the SEC fiduciary rulemakings. And it's understandable. I think just a normal person, not somebody like any of us.
Real lives.
Yeah, exactly. Thank you, Dale. Why they would be totally confused about what's going on. I think Dale and Ira and the insurance industry have done an excellent job of going to their allies on Capitol Hill and expressing their concerns about the DOL rulemaking. Unfortunately, that debate has been translated through the lens of this SEC rulemaking. Right. And the simple fact of the matter is ERISA, which is the DOL's statutory basis for doing this rulemaking, is very different than the SEC statutes. So it's kind of ironic. There are a lot of voices on Capitol Hill who are expressing concern about the DOL rulemaking, saying the two agencies should work together. Look, all of us are for regulators working together. That's fine. But what they're missing is that there are separate statutory bases for both of these rules. Congress, ironically, was the one who wrote those different rules. And I think you have to take the DOL rulemaking somewhat on its own, mm-hmm. unless Congress comes in and changes the statute. And you have to look at the SEC rulemaking separately. That doesn't mean that the two agencies shouldn't have some level of knowledge of what's going on, but the bottom line is you have two different statutes.
Does anybody disagree?
Well, no, don't disagree. It just the everyday business reality is, at least our members, and I'm assuming members of other organizations represented here, have to operate with clients every day under both fiduciary duties, under both statutes. And so I think we have an interest in, don't have any illusion that suddenly the two agencies are going to harmonize ERISA and the Investment Advisors Act, but I think it's helpful to hear that they're talking and attempting to coordinate and playing off of the different cost-benefit analyses that are underway. Hopefully that'll end up, again, avoiding serious unintended consequences for small investors who need help.
And I think for us, NASAA certainly supported the original DOL fiduciary proposal. We certainly don't want to see that watered down. We're extremely, extremely worried about tying the Section 913 duty to this ERISA duty, drawing an analogy to what you mentioned earlier about the letter writing. If we have to get all of these parties together on the letter writing, guess what? We're not going to have a fiduciary duty for a while. And again, I think that the issue is not having a fiduciary duty under ERISA and a fiduciary duty under the IA and a fiduciary duty under broker-dealer, because the fiduciary duty itself is essentially the same. It is the contextual application of that duty that makes things tough. And for me, that doesn't have to be decided on the front end. I mean, you give as much guidance as you can, but you're not going to be able to anticipate every factual scenario. But like I said, I think NASAA's big concern is tying the two, and it gives us a lot of concern.
did you have something, Ira?
Yeah, from the SIFMA standpoint, we're concerned that the DOL reproposal might limit choice. So similar to what Dale was saying earlier, and until we see the words on the page, it's hard to know the impact. But when you ask what are we concerned about, we're concerned that if they continue the way they did on the initial proposal, you would have millions of IRA accounts, typically smaller accounts, being forced into a different way of paying for their advice. So that's a concern. And the other thing I would just observe is that whereas a lot of what we're talking about today stemmed from the financial crisis, that 2008 time period that gave rise to the Dodd-Frank Act that we're about to celebrate the 3rd anniversary of. And there's the Title IX in Dodd-Frank, which deals with so many of these consumer investor protection issues. Well, this DOL fiduciary one was not part of that. On a totally separate track, the DOL wanted to, as I understand it, I'm not an ERISA lawyer, they wanted to improve their statistics, their results in bringing enforcement actions with respect to ERISA plans. So there was this original 5-part test, and they wanted to modify that to make their enforcement program more robust. It might be a totally legitimate method to achieve that, but coming at the time when everybody around this table and all the regulators and all the other interested folks are trying to implement the Dodd-Frank law, and as we all know, we have something like 400 rules to implement, and we're only about 1/3 of the way there, to then add on top of that this DOL fiduciary new definition is just further complicating what's already a very complicated situation.
Great.
Let's move on to the next subject. We've been talking about DOL-SEC coordination, and the SEC now has a brand new leader, new Chairman Mary Jo White. And Heath, you're going to meet with Chairman White soon, just later on the day that we're taping this roundtable. What kind of conclusions, if any, can we draw about Chairman White in her first 2 months on the job?
Well, I think that we're certainly encouraged by her efforts to make it a priority to increase investment advisor examinations. I think it's probably a little premature to make too many judgments about Chair White because, most of her deputies, there's a number of them that haven't even joined yet. She hasn't really had a chance to put her team together. I can say we were extremely disappointed that she didn't take the opportunity to follow up on the letter that 36 members of Congress sent her dealing with mandatory arbitration provisions. However, she seems very open and willing to talk with us, to hear our concerns, which is a good sign. So I think that the jury's still out.
And David, what about you? What have you observed?
No one knows what Mary Jo White and how she's going to run the SEC. If they do, I hope you'll let me in on the big secret. But it's clear, Mark, she has a very distinguished tenure as a prosecutor, certainly. So I think you can expect a continued enforcement type of a focus from this chairman. I think on policy issues, we're all waiting to see. There was a vote last week by the Commission on money market reform, which has proven to be a very difficult issue and a very important issue. I think the fact that she got a vote and got a proposal out signals to me that at least this commission could get several other things out. You've got the Jobs Act, Volcker Rule, some pretty big unfinished Dodd-Frank business or legislative business that's out there. So we're very curious to see what it's like to work with this chairman, as well as you've got 2 appointments that are pending, and so you're going to have a majority of the commission that is relatively new in the next 2-3 months.
Right, and Ira, from Wall Street's perspective, Mary Jo White, during her confirmation hearing, gave reassurances to Senator Michael Crapo, the ranking member of the Senate Banking Committee, that she would take cost-benefit analysis very, very seriously, including specifically the fiduciary duty cost-benefit analysis. In this money market proposal, it seems that she's at least calmed the waters in the industry about how far the SEC would go with money market reform. It seems that she's spending a lot of time and effort in trying to reassure Wall Street. Is that a fair assumption? I mean, a fair conclusion to draw?
I certainly did not read that in or get that inference.
All right.
To echo David's observation, she is a dedicated public servant who has a terrific reputation as a former prosecutor. I think from her early hiring, you can see her reaching out to people who are, like-minded in terms of their government service and their terrific backgrounds. So while, yes, she has a few more slots where she needs to fill, I think she's really started to put her team in place, and up and down, they seem to be very well qualified and capable. And all I would read into the money market fund proposal that came out last week is she's going to get things done, and she'll work with her fellow commissioners. As again, David pointed out, we're in a time of transition. We'll get a few new commissioners. But I think her agenda, certainly for the foreseeable future, has to be focusing on the Dodd-Frank implementation that remains on the books, the Jobs Act implementation. Those two topics alone, I think, have to dominate certainly the next 6 months or so. And then other issues like the one we started talking about today, I'm sure are significant importance. There'll be parallel processing, there'll be forward momentum. But in terms of things that she has to get done, I'm thinking of things like the Volcker Rule and the Jobs Act implementation, money market fund reform, things like that.
Right. And Marilyn, the two nominees, Kara Stein, coming off the Hill from the Senate Banking Committee, Senator Jack Reed's staffer on that committee, and Michael Pivovar, who is a Republican staffer on that committee, an economist on that side. What do these appointments say? What's the Obama administration trying to accomplish with these two appointments, people straight from the Hill?
Well, I think certainly both of the nominees are very well qualified. They both have experience on the Hill with Dodd-Frank, and so I would imagine that they can be very, very helpful and constructive in the Dodd-Frank implementation. And so certainly one of the positive things I think about the two new nominees and Chairman White is that we will have a whole new commission who will be making decisions, and particularly on the topic that we started with, on the 913 fiduciary standard of care. It will not be the same, essentially the same commission that voted out the request for information and laid out the assumptions that we have concerns about. It'll be a whole new commission that will be making that very important decision. So we think it's very, very positive, and hope that the nomination process goes very quickly and smoothly and efficiently so that the commission can get to work.
So, I'm sorry, David, go ahead.
If I could just add one, it's really to put an exclamation point on something Heath was talking about, and I agree with IRA, Jobs Act, and Volcker Rule, and some of this unfinished business. But in her first two appearances on Capitol Hill, first before the Appropriations Committee on the House side and then the House Financial Services Committee, in her written testimony, it was investment advisor examinations and the need to beef those up. That was the first topic that Chair White addressed. We're pleased that she chose that emphasis, but the jury remains out about how far she can get on that and how congressional appropriators or authorizing committees deal with those issues of SEC resources.
I think that perhaps the biggest change we'll see with the new commissioners, having worked with both Kara and Michael, is, and it's only my supposition, that the current commission is crippled by its inability to gain a consensus amongst the commissioners.
Right.
Kara especially has, at times shown herself to be very much aware and a friend of the interest of retail mom and pop investors, but at the same time, she has a very reasonable and balanced approach. And I think Michael's exactly the same. He is an economist, but he's very pragmatic. And so I think that what we're going to see is hopefully what we're going to see is a commission that is going to get moving on some of these rulemakings, because I think there will be an ability to gain a consensus and gain the yes votes that's needed to move things through.
And that leads into the next topic of conversation. David, you were talking about the SEC budget, and of course that is related to oversight of investment advisors. The bill that's out in the arena at the moment is Congresswoman Waters' bill that would authorize the SEC to charge user fees to advisors to fund advisor examinations, and of course she's the ranking member of the House Financial Services Committee. And David, on that bill, what are the prospects? It's sort of out there all alone at the moment. There's not an SRO counterpart bill the way there was last year. Where's this going to go?
I don't know for sure. I guess if I were a betting man, I wouldn't put a lot of money on anything moving, either an SRO bill like Chairman Backus had last year, or the Waters user fee bill. We had some people in town last week, as you know, Mark. We had our annual lobbying day and sent people up to Capitol Hill to talk to their Congress people. And certainly one of the messages was, if you're amenable, we'd like to see you co-sponsor the Waters bill. I think you'll see a few more co-sponsors, but I don't see any sign that Chairman Hensarling is ready to take up the Waters user fee bill and move it through the committee anytime soon. There's a possibility that companion legislation could be introduced in the Senate, but it has not yet been. And then there's also, to me, the question of what are the SEC resources going to be in the whole authorization. Well, I guess the authorization is actually there. It's what's the appropriation going to be for the SEC for 2013 and beyond. That's very much a mystery to me, and I'm sure that there'll be a big debate about what the SEC resources should be.
Sure. And Marilyn, where do you see that debate going? We haven't, at least the last time I checked, haven't heard from Chairman Crenshaw of the House Appropriations Subcommittee on Financial Services. But what's your feeling about how Republicans are going to, especially the Republican House majority, is going to receive the SEC's budget request?
Well, certainly the budget request, I think, faces the kind of difficulty that appropriations requests have faced traditionally for a very long time. So I think we're very interested in seeing a solution put into place that will address what remains a very serious investor protection problem. Congress recognized the problem in Dodd-Frank in Section 914. The SEC recognized the problem when it did its 914 study. It put a couple of options before Congress. We, along with the Investment Advisor Association and others, strongly favor the user fee legislation. You have a targeted, narrow, common sense solution that has no impact on the taxpayer or the federal budget and can address a serious issue. And our concern is at this point in time, investors are not sufficiently protected as long as investment advisors are examined once every 11 years, or roughly 8% of investment advisors examined on an annual basis. The advisors don't like that. It's bad for investors, it's bad for advisors. The advisors strongly favor, by over 80%, the user fee solution. So we're hopeful that, and our job is to educate members of Congress that this is a very common sense, narrow solution, and it's time for action now before we have the next crisis.
Dale, last year FSI was one of the chief proponents for the SRO bill by then House Financial Services Chairman Spencer Backus that would authorize one or more self-regulatory organizations to oversee investment advisors, and the Financial Industry Regulatory Authority was the chief proponent of that. This year, Congressman Backus, he's no longer chair of the committee, but he hasn't introduced a similar bill this year. Do you see the SRO idea coming back, or would you like to see it reemerge?
I don't see it coming back anytime soon. I think what we've got here is there's agreement that the status quo of insufficient resources for examination of investment advisors is not acceptable. You've got various policy solutions and absolutely no political support coalescing around one of them. There was no political support on the Hill for the SRO legislation last year, in spite of best efforts on a lot of folks' parts. I see no strong support for Ranking Member Waters' solution, the user fee legislation. So our approach now, until we see more of a consensus building on something that's achievable legislatively, is we're focusing on FINRA reform. They're our members' principal regulator. They are already extending their reach into the investment advisor arena, and which definitely impacts our members. And so we're deepening our engagement with them and encouraging several areas of what we think will be important reform, which either help them improve if none of these solutions ever emerge, or if one of them, like the SRO, if the environment changes and we can get some SRO legislation through, they'll be in a stronger position.
Are there any other, we're talking about, the two kind of solutions, which is the user fee or the SRO, but is there a third or fourth kind of idea that anybody here has heard kind of bandied about that could come up as a surprise?
Well,
sure. Congressional funding.
I was just going to say that
Novel idea.
That's the easy one, is for the SEC to get additional resources. That's paragraph 1 of Mary Jo White's appropriations testimony from 2 or 3 weeks ago. Fred, there have been other options as well, but they haven't gained any traction. And the main one I'm thinking about is to have some third party, like a compliance review type of requirement. Actually, when Mary Shapiro first came in as chairman in 2009 and post-Madoff, and they redid the custody rule, she said openly in public statements leading right up until the custody proposal came out that this third-party review was going to be part of that review and that part of that proposed rule, and ultimately it was not. So that idea is around. You asked the question, are there other options? Yes, but nobody's waving a flag. Certainly the resource issue, though, and even you look at a Republican Congress the last 2 years, I think a lot of people, I was surprised at the level of funding that the SEC has received. They've received $200 million additional since the Republicans took over the majority in the House. So I don't think you can completely write off the possibility that the SEC will get any increase. I'm not crazy enough quite to believe that they'll get what they've asked for, but there's a lot of difference in between those two extremes.
And I think there are a few options. One would be a very in-detailed audit of SEC spending and reallocation of that spending based upon perhaps overlapping jurisdiction with state regulators. And when you think about it, the SEC has the same jurisdiction over we do that we do in most cases, with the exception being state registered IAs. Seems like a very horrible allocation of resources, that maybe we got some room there. And one of the other things we talked about is spin-off of sections that could be funded by the industry, by user fees, whether that's Corp Fin, BD, and IA. And you have enforcement funded with general revenues, but there's some creativity you could get into there. I think for me, what's extremely frustrating is that Congress has expressed its displeasure with the SEC, expressed its displeasure with the SEC's oversight of investment advisors, yet in the Jobs Act gave the SEC a number of very specific sections and said, you're the only regulator that can act here, and by the way, we're not going to give you any more resources, and we're going to outsource the regulatory function to a third party. It's Congress punting the ball when it shouldn't. The regulation is inherently a government function, and it should be retained a government function. And Congress, if it really is resource allocation that is causing the SEC to fail in this area, it's Congress's job to fix it, not to give it away.
Heath, let me move on to another subject, and this one involves you because I know you've been very active, and I'm going to talk about mandatory arbitration. What are the prospects this year for ending or reforming mandatory arbitration, do you think?
I'm told they're not good. I refuse to believe them. But it was something you mentioned a minute ago when you talked about the average size of an IRA account, and you said it was $27,000, right? Mm-hmm. Okay, if that account holder is subject to some malfeasance by his broker dealer, or let's just stick with broker dealer, what are his reasonable remedies? If he's got a mandatory arbitration provision with the Charles Schwab class action waiver, that means he's going to arbitration, right? That's the only alternative he has. Find a securities lawyer that's going to take a $27,000 securities fraud case. It's not going to happen. And I think that it's not just that mandatory, yes, we have concerns about mandatory arbitration and the fairness of the proceedings, the fact that FINRA has the panels, it's a FINRA arbitration. Don't even get me started with FINRA expungement. We have all of those concerns, but we're also concerned that the way it's set up now, it really presents an absolute prohibition and an impossibility for small investors to seek redress for securities fraud. And I think this is going to be especially true when you consider what's happening in the Jobs Act. The only way we're going to facilitate the Jobs Act and investments in the Jobs Act and hopefully new jobs is if the money comes in. Well, no one's going to invest $2,000 in a crowdfunding offering. No one's going to invest $50,000 or $100,000 in a 506 offering if at the end of the day they know they can't sue to get their money back if the broker-dealer lied to them. So outside of the fairness issues, outside of the fact that I think it really cuts off an avenue of redress for small investors, I think we're shooting ourselves in the foot on what we want to do with the Jobs Act, because those investors are also going to be denied the right to recover. And unless this is fixed, the Jobs Act's never going to work.
Right. Ira, what do you think about mandatory arbitration?
Ira agrees.
Yeah, I was going to say, no surprise that I don't agree with everything Heath just laid out. First of all, the arbitration system that we have today is a fair system. It is one where customers who have small claims can go and have those claims resolved. I mean, a customer can literally fill out in handwriting a piece of paper and submit, and even in that $27,000 account, have their so-called day in court. Where if it was real court, there's no way that anyone would be able to pursue that sort of a case. So the arbitration system has been scrutinized every which way, has been modified, improved. There are a variety of academic literature out there, so it's not a SIFMA position, but look at the literature, and it is a fair system. Brokers are compelled to arbitrate. There's a FINRA rule that says we must arbitrate. Pre-dispute is where you should have an approach laid out as to if there is a problem, which way will it be resolved. Now, the Supreme Court said in the McMahon case and other cases that having a mandatory arbitration provision in the contract is an appropriate way forward. And that's the way it's been. I think to do away with that and let customers decide either before the dispute or after the dispute will just whittle away the effectiveness of the system and the infrastructure surrounding the arbitration system.
Well, I think that.
I'm sorry, Heath. Let me just, Dale.
Just another perspective on this, not necessarily different. We've been hearing from our members, again, who are independent broker-dealers and independent financial advisors for at least the last year now, a growing concern, and maybe I can use the word disenchantment with the arbitration system. Believe in the concept, but the reality they're experiencing is it's becoming more unpredictable, more costly. They understand that we want to make sure it's a fair forum, but what we've had in the last year is an attempt to move industry participants off of arbitration panels, and our view is that's short-sighted because industry participants bring a perspective on how things really work, and I think add to the fairness of the proceeding for investors. We're seeing panels inconsistent on application of statutes of limitations, inconsistent on rules regarding discovery and evidence, and this, I can't say this is widespread, but we've identified some number of supposedly, what's the right word I'm looking for, impartial arbitrators who are actually deriving 100% of their income from suing broker-dealers and advisors, and yet they're getting named as panelists on arbitration panels. And so we're working, again, this is one of the areas where we're engaged with FINRA. We've created a member task force focused on this issue, pulling from experts in and outside of our membership, going to be engaged directly with FINRA. We've already started conversations with state regulators as well about it, and hopefully be able to bring forward some solutions, because it's got to work for small investors because of the dynamic that Ira cited, that the court system is just too high a barrier, too costly. But it's also got to work for industry participants as well, and I think we're going to work towards that solution.
Okay.
Heath, you want to make the final point on this?
You know, I think it's extremely short-sighted to assume that the $27,000 client feels safe and comfortable to initiate an arbitration act on his own when he's going to get faced down by the attorneys representing a broker-dealer firm. And to think that that's actually a fair forum I think is absolutely wrong. Dealing with what you mentioned about the industry participants and adding fairness to the procedure, I absolutely disagree. Industry participants means they were there as employees of the industry. They understand how things worked in the shop. I don't want a broker deciding my arbitration matter. I want a judge deciding my arbitration matter. And the panel inconsistencies that you talked about is because the way this arbitration is set up, arbitrators aren't allowed to research the law. They're not allowed to take a look at what the law is. These aren't judges. The only thing they're allowed to consider is the message that's given them, and then decide based on that. Well, these are legal issues, no matter how you look at them. And I think the entire procedure is set up in industry's favor, and it needs to be reformed. Now look, I'm not saying that if I have a claim that's $500,000, $600,000, I'm sophisticated. I probably understood the nature of that arbitration claim when I signed the document, and I play the hand I'm dealt because I actually called for that hand. But when you're talking about a client that's got $20,000, $25,000, $50,000, I mean, the net effect of this arbitration provision is to ensure that they have no fair route to recovery. For all of those reasons, and I'm right.
We'll let you have the last word on that section, Heath. We'll we'll acknowledge your passion.
This was not the first.
Moving on to the next area, Dale. This is related to what you were saying about FSI working with FINRA on some FINRA reforms. Let's look at some things FINRA will be doing soon. Rick Ketchum a couple weeks ago said that the broker compensation rule would go before the FINRA board in July. That rule basically says that if a broker gets more than $50,000 in incentive compensation, he or she has to disclose the details of it. What do you anticipate? I know FSI had a problem with the original rule. What do you hope that the new rule? How do you hope the new rule will be changed from the original one?
Well, it's encouraging that they heard the feedback and withdrew it and are going to come back with a reproposal. I think that's always positive. Mm-hmm. Our concern is that it drew too hard line at 50,000 and made no distinction between the different types of compensation that are involved when a rep or an advisor is moving from one broker-dealer to another. We think the disclosure ought to be around compensation or bonuses, retention bonuses, recruiting bonuses that create an actual conflict of interest that have the potential to harm the client, versus what is a frequent practice in the industry, particularly in our segment, where the new broker-dealer will offset some or most of the transition costs for that advisor moving from broker-dealer A to broker-dealer B, relicensing fees, new letterhead, new account fees, if there's a transition to a new clearing platform, those kind of things. That's a common practice. Most of the time that's not creating a conflict of interest. In fact, the new broker-dealer covering those costs actually, I think, often is a good thing for those clients when that transition is happening. So we want to see them make more distinction and focus the disclosure requirements where it creates a real conflict, potentially to harm the client.
And Ira, what would SIFMA like to see in the reproposal?
Yeah, fairly similar. So it should be conflict-based. That should be the catalyst for disclosure. And then the SIFMA membership is, I guess, split. There are some members who very much want specific dollar amount disclosure. And then there are others that think a more generic disclosure would be appropriate. But the key common denominator would be some type of disclosure to the customer if there would be a conflict of interest.
Mm-hmm. And conflicts has been a big theme for FINRA over the last few months, and certainly in 2013. And they're doing a survey now of their member companies and are going to post results about that sometime soon. Does anyone here at the table foresee FINRA coming out with new conflict rules this year? I mean, is this an effort that's going to bear fruit in that way?
I don't know if we'll see rules per se, but first I think they should be given credit for engaging in a thorough review. I think 14 firms of different shapes and sizes. They've spent time with senior management from those firms, as well as legal and compliance and so forth. And rather than just keep that information to themselves, they're going to share it with everybody, and that's what you're referring to in terms of a July time frame, where we should see some output from FINRA where they're sharing what they heard. So I think that's a great next step. Whether it ultimately leads to additional rulemaking, I guess time will tell.
Has anyone seen their survey that they sent out? I'm just curious whether that you were able to pick up anything about where else they might be looking for. Nobody seen it? You're going to say something.
Well, just to follow up on Ira's comment, I think Rick Ketchum recently at their conference last month, commenting on this, indicated that at least he has a bias potentially to take action on this area of conflicts of interest and disclosure if the SEC doesn't move forward in a timely fashion on a fiduciary rule. So it'll be interesting to see how that dynamic plays out. At this moment, don't have any specific insight into his thinking beyond what he said publicly.
And FINRA also has embraced cost-benefit analysis. They've hired a chief economist. They seem to be moving forward in an area that certainly has generated a lot of interest from Hill Republicans. How do you, from anyone around the table, what do you think about FINRA's moves on cost-benefit?
I think it's a very positive move. I think they're trying to you could argue they're trying to get ahead of the curve. You can argue they're trying to catch up. Either way, the idea that they've got now a trained, very experienced economist who will lead an effort to both on prospective rulemaking, make sure there's robust and dynamic cost-benefit analysis. But we are also encouraged that they've said they're gonna do some look back. They're gonna look at existing rules on a regular basis and ask, are they still accomplishing? I think that's a very positive development.
Is there anyone at this table that's dubious of the cost-benefit argument? I mean, I've heard people say that it's a move to slow down regulation.
Yeah, I don't know that I share a lot of what Dale said. I know when I testified last year before Chairman Backus and his committee, and they were talking about cost-benefit analysis, and I pointed out that FINRA, they talk a good game on cost-benefit analysis, but the bottom line is they can't be sued like the SEC has been and have rules invalidated. But there's a lot of, I think this is a moving target. Certainly, I don't think anyone would disagree that their cost-benefit as an issue on Capitol Hill is not going away. Where the hell it's going is very uncertain. And there was a bill that passed the House Financial Services Committee recently, Chairman Garrett's cost-benefit bill, which the administration opposed vigorously. The SEC said it would handcuff it. But FINRA, there was an amendment to that bill that passed successfully that added FINRA and some other SROs to the cost-benefit analysis. So I think we're going to continue to have cost-benefit analysis. I think from an industry viewpoint, we all view cost-benefit analysis as an important part of any regulatory proceeding. But how far that goes is the real question.
You know, and that's the concern that we have. I think all of us at this table would support a reasonable cost-benefit analysis. Certainly we don't want to see any rules or regulations passed by any entity that wouldn't have something like that. However, under the guise of cost-benefit analysis, you can in effect create a wholly unreasonable system where rules, you in effect control the rules that are coming out. And I think that I think it's very telling that this push for an enhanced cost-benefit analysis is happening right now, when the SEC is under such pressure to put out rules that are still subject to political debate, and all of a sudden we have this heightened cost-benefit analysis. I mean, that's not just happenstance. It's there for a reason.
Why don't you have the final word on
Well,
this?
it's just using cost-benefit analysis as a way essentially to hijack prospective rules that were part of Dodd-Frank is the wrong way to use cost-benefit analysis. And it also allows for a heightened ability of people who may just disagree with the rule then to be able to challenge the rule on a basis that we think is just not appropriate.
So the bottom line is that everyone seems to agree that cost-benefit analysis is good, but that it has to be, it's a powerful tool that has to be used correctly, I guess. Absolutely. So moving along to our final point, because we're getting towards the end of our time here. What I think would be a nice way to close this is to go around the table and to ask each of you to kind of summarize in 30 seconds or so what you're expecting, either in the way of regulation or legislation or both, for your members. I mean, what are you talking about with your members for the important issues for the rest of the year? We'll start with you, David.
I think at the SEC, we've mentioned it already, it's Money Market Reform, Jobs Act, and the Volcker Rule are certainly three high priorities for the Commission. Some of those could affect investment advisors depending on their size and shape. The Division of Investment Management has actually published its 5 highest priorities. Norm Champ did that several weeks ago, and there are things like valuation and private fund issues and some other things. So that's what I'm expecting. I think the request for information on fiduciary is out there someplace, and then this very important question about SEC resources that will be part of the bigger budget battle of the United States of America.
Dale?
Fred, our highest priorities for the remainder of the year are engaging on this Department of Labor fiduciary rule proposal we're all anticipating. We're also, as I've mentioned before, our other priority is FINRA reform, and all in the context of just about everything we've talked about here is a political climate that's now being consumed by scandal and sequester. Makes it very unpredictable what will happen on the Hill, and that also, what happens on the Hill has direct impact in the regulatory agencies as well.
Mm-hmm. Absolutely.
Like we said before, I think that we're heading toward a showdown on the fiduciary issue with proposals looming from both the SEC and Department of Labor. And I think it's very important that those fiduciary standards don't get watered down. We remain concerned that Congress is going to severely impair the SEC's ability to conduct reasonable and timely rulemakings through this cost-benefit analysis. That's a big concern. What we'd like to see is the SEC finally consider ending or limiting forced securities arbitration and certainly class action waivers. And also, the SEC's got to address, and Congress has to address, the SEC's funding request to provide a reasonable, effective, and efficient system of examining investment advisors.
Sure. Ira?
So for us, the DOL fiduciary issue would be the top issue for the remainder of this year. As we discussed earlier, we are expecting to see a reproposal from the DOL, so we want to be very engaged in that process, and even leading up to that process, we will continue to be engaged. Beyond that, the Dodd-Frank implementation. So as David was saying, things like the Volcker rule, under Title VII, there's some cross-border guidance that the SEC has pending, money market fund reform. But basically, there'll be this steady move to continue to work towards implementing all the Dodd-Frank regulations that are required. And then hopefully the issue that we talked about at the beginning, the 913 fiduciary, will continue to be high on that list, but it might take more to 2014 to really see some forward momentum.
Great, thank you. And Marilyn?
So Fred, we might be a little unique because we're not a membership organization.
Right.
CFP Board is a nonprofit organization, and we certify over 68,000 certified financial planners. Our mission is to benefit the public by granting and upholding the CFP standard is the standard of excellence for financial planning, and so our public policy is also guided by what it benefits the public. So in a recent survey we did, 95% of those we surveyed of American investors out there said that they think that that the person providing them with personalized investment advice should put their interests first and foremost, and should disclose all conflicts of interest. And so a guiding policy position for us at this point in time is the fiduciary standard of care in Section 913 before the SEC, and then also the issue of making sure that investment advisors are examined appropriately to protect investors. And then finally, I would say that there's sort of a broader issue out there. We think that those people who hold themselves out to consumers as financial planners, if they're not qualified, they don't have the competency, or they're not operating at the appropriate standard of care. It's a long-term goal for us to address that really important investor protection issue.
Great, thank you. Well, there you have it, a mid-year review. I'd like to thank all of you for participating in this roundtable. It was fascinating, and there's obviously a lot to keep track of, and I'm sure for our readers you really gave them some guidance, so thank you very much.
Thank you.
Thank you all.
Thank you.